No, right. That is one part of it. The first thing to understand in a case like this is that a murder trial does not begin with the emotion. It begins with a categorical structure. A criminal court altogether in India does not ask what does this look like on the social media or what does this look like on a print prima facie. It asks a much harder question: and has the prosecution proved beyond reasonable doubt that Sia and Ketan committed the murder, and that every essential link in the chain is supported by a legally admissible evidence? And that is the basic difference between a media narrative and a criminal trial altogether. So, in public discussions, people often um, begin from the conclusion, and they work backward. They already know and appear and seem to have an opinion about everything that they see, and then they look forward and backward. That is how our mind process things. But criminal law does not mix the assumption, which are not categorical, chaining to the material facts of the case. They hear that Sia was with Ketan, Ketan died, and therefore Sia must have done something. But in law, that is not how guilt is technically established. I mean, presence, there are a lot of factors that we see in this particular case that, of course, raises the question and suspicion. Presence, of course, being one of them. And suspicion may justify the investigation. But suspicion is not the proof. A session court trying a murder case under the Bharatiya Nyaya Sanhita will separate the facts into categories. And that is what it is need to be understood. Because if you do not understand this whole chain of circumstances, this whole chain how the criminal law works, you will never be able to understand this whole scenario. So there are facts that are undisputed, there are facts that are disputed, and there are facts that are only inferred. And this distinction is very very critical because you see, the moment a court allows inference to masquerade as a proof, the standard of criminal justice will eventually collapse. Now, if we apply that method to this case, the undisputed facts appear to be these, I would say. Sia and Ketan, knew each other. They were engaged. They traveled together to Lohagarh Fort on 18 June on 2026. Ketan later fell from the fort and died from injuries. And police, of course, later arrested the Sia and the alleged boyfriend. Those facts matter. I would not say these are the things that would not establish the motive. Of course, they will do, but they do not by themselves establish the murder. They establish a relationship, opportunity. There is a movement to this tragic death of Mr. Ketan Agarwal. They do not prove any kind of intention, planning, or the actual act of pushing. That is where the court will shift from the background facts to the disputed facts. What are the disputed facts? Did Sia push Ketan? Did the alleged boyfriend assisted her? Was there a conspiracy? Was Ketan was alive and then suddenly killed? Or did he slip in an accident? Now, this could elaborate into, or this could extend into, was it a premeditated act, or a sudden quarrel, or a staged fall, or a tragic mishap which maybe Sia is also not wanting to. These are the permutations and combinations and the probabilities that you see. These are the real questions. Everything else is only the context. So a defense lawyer would immediately focus on this gap between the context and the proof. The prosecution may say that Sia and Ketan were in a relationship. Sia and the alleged boyfriend were in a relationship, and Sia allegedly did not want to marry Ketan. That may create a motive, but motive is not the same as guilt, and that is very important to understand, guys. Because in criminal law, motive is only one circumstance among the many of them. I would rather paraphrase it. It is the motive is only one circumstance among many. So it can help explaining why a crime might have happened, but it cannot prove that the crime did happen in the manner alleged. You get what I'm saying? This is the complexity of how our mind has functioned. We have been, rotting our mind from since childhood, and that is the sad part of it. Because now, when you learn law and when you understand the trial, how the trial works in the court, you will see your mind working upside down. You know that is how it should be. Thousands of people have, unhappy relationships. Thousands of people have secret affairs. Thousands of people have family pressure or a conflict over the marriage. Courts will not and do not convict people for having a complicated emotions or a difficult relationships or having a boyfriend altogether. They convict only when those circumstances are tied to a legally proven act. So if the prosecution says Sia wanted freedom, she feared the social stigma, or allegedly wished to avoid the marriage, the defense. The defense will answer that all of that may be a gossip, a character suggestion, or a background motive, but it still does not prove that she pushed any off a vote. So the prosecution can argue that these are the things that she wanted, these are the facts, these are the social digital records of this lady. She was feared with the social stigma. She was allegedly having a relationship with another boyfriend, and that is why she killed. She killed in the question, and you cannot have a circumstantial evidence which apparently does not connect to each other. Maybe in a layman language it would, but in reality, in practicality, it does not. It does not make sense. And that is why the next layer becomes the doctrine of what? Circumstantial evidence. And this is the real battle in a case like this. When there is no witness, there is no direct CCTV of the push, and no clear confession that can be used in the court. Now, what the prosecution has to do, now every person in the prosecution world will do, has they will have to build a chain of circumstances. That chain must be so complete that it excludes, again, listen, that chain must be so complete, so accurate, so linked to each other that it excludes every reasonable hypothesis of a innocence. Who is the innocence and what is the innocence? That even an iota of doubt would not suffice her as a guilty. In a plain language, I would say every link has to fit. If one link is missing, or if I would say if one link is not matching, or doubtful, or inconsistent, the chain weakens. In this case, if you see, the prosecution will definitely try to build that chain from what? Relationship, alleged motive, travel records, location data, where were they? Were they together? The CCTV, the alleged cafe meet, the phone records, the deleted chats, internet searches, the alleged Snapchat messages, the presence of a hooded figure, who was he, and the recovery of the Ketan's body, and the conduct of the accused after the incident. But the defense will test each link separately. It will ask, does this fact prove the murder? Does this fact Does the travel record prove the murder? Does the location data prove the murder? This is the question that the court and the police will go into. Or does it only prove that two people were together and something terrible happened afterward? Now, there is a very famous theory, that is what? The last seen together theory, which and will be one of the strongest circumstances for the prosecution. But it is not enough by itself. You see that courts often accept and they accept the last seen evidence when the gap between the accused and the death is so minor, so small, that no reasonable alternative explanation remains. But that is exactly where the defense will attack. If Sia and Ketan were together at the fort, that establishes the opportunity You see what I'm saying? The exactly where the difference is lacking. Sia and Ketan were together at the fort. That will definitely establish the opportunity. It does not prove the act. If Sia called Ketan's mother at around 10:45 a.m. and said he had fallen, that may create suspicion, of course. If the call sounds casual or inconsistent with the grief. But suspicion about tone or behavior is not the same as proof of homicide. The defense may say that the fall could have been accidental, that the terrain was very dangerous, that the fort had steep sections and gorges, and that no one can simply assume the push. In other words, the defense will keep returning to the same legal point. Every fact that the prosecution relies on must point only towards the guilt and not merely towards the possible guilt. That is a difference that as a legal acumen you have to develop over a period of time. Even I am in my fifth year, I'm learning, I'm trying to make sense of it. है ना? Anything that you see around, now your mind should have a legal acumen. You should not think like a layman. Everything that you see around should have a legal understanding of how it should proceed with. Now the digital evidence, and I that believe that will likely be the most important piece of for the prosecution, and and also the most vulnerable if not properly proved. I would say I'll explain how I'm saying that. Allegations about the deleted chats, search history, calls, messages, and Snapchat communication can become very powerful if they are, properly extracted, certified, and linked to the accused. But electronic records are not magic. A screenshot on the social media is not enough by very nature, by very itself. Under the Indian evidence law, the electronic evidence must be handled very carefully. The court will ask whether the original device was seized or not, whether the extraction was forensic or not, whether the metadata is intact or not, whether the timestamps are reliable or not, whether the chain of custody is intact or not, and whether the records of comply with the certification requirements for the electronic material is done or not. If the prosecution says he has searched for ways to kill a person, or that the accused changed thousands of calls altogether, or that a coded chat hinted at the planning, the defense will demand the extra source, exact source, sorry, and that exact extraction method and the exact context is what we require. A search query or a search query will not alone does not in any way prove the intent to kill. A deleted chat alone does not prove the conspiracy. There's no conspiracy when you delete a chat. I do it 10 times a day. Does that make me guilty of doing a murder if I committed a murder? Maybe that those two can be isolated acts. A coded message alone does not prove the act. Our mind is wired in a way that is making one thing eligible, that is to believe in the assumptions. And as a legal acumen fellows, we do not have to. There's a lot of unwinding up has to be done with the mind. All of these may be suspicious. All of this may be very doubtful, but suspicion alone only cannot become the legal significance when conducted to the other verified facts. This is also where the alleged motive narrative becomes legally important, but it is still incomplete. Because you see, the prosecution may argue that Sia was engaged to Ketan, but was allegedly in love with the boyfriend, and therefore wanted to remove the Ketan rather than openly cancelling the engagement because of the family pressure and social stigma. Now, that is a coherent theory that everybody is spying around you, social media to the woman hater and the men hater, everybody, the sections that we are divided and believer we have become over a period of time on social media, which we feel that we are very part of this group or section. Of course, in sociology all these groups are vital, and they make you sound cool, they make you feel grounded as a part of a group, but that is not true. It may even sound persuasive in a television debate, but in court, a persuasive theory is still not enough unless it is supported by the independent facts. Am I making sense, guys? Am I making sense? Please say yes. Yeah, okay. For example, let's move further. For example, if the prosecution can show that Sia and this alleged boyfriend communicated secretly, they met at a cafe late at night, exchanged coded chats, searched online for killing methods, and then traveled to the fort together with Ketan. The theory becomes stronger, but even then, the court must ask whether those facts prove a planned murder or whether they are merely consistent with a secret relationship and a suspicion conduct. Guys, criminal law demands more than consistency. Consistency is not the proof. It demands proof that is linked in such a way that it does not leave an iota of doubt in the mind of the judge that she is innocent, that she could be innocent. Am I making sense? Am I making a logic, guys? Great. So the absence of a direct evidence is where the defense gets its strong opening. There is reportedly no eyewitness who says I saw Sia pushing Ketan. Neither the CCTV recording of the push itself. Whether that was a push or she was trying to attempt to gather him. There is no direct video of the fall. There is no eyewitness confession and no admissible confession that resolves the core question that the prosecution may have a CCTV footage of a hooded figure near the site. But if that figure is only allegedly this guy, this boyfriend, then the defense will challenge the identification. A hooded figure in a fort area is not automatically a proven co-accused. The defense can also argue that the fort was a public trekking destination that many people could have been present. But then, of course, uh, that is how it is proved. But again, same jacket, same hoodie could be different people altogether. Does we see the same person in the hoodie? And that a silt house or distant image is not enough to establish who committed the act. If the prosecution says this alleged boyfriend was present nearby, the defense may respond and say that presence is not the participation, my lords. And the prosecution needs to understand if the prosecution says Sia had Ketan's phone afterward, the defense may again ask how that proves the murder rather than mere post incident confusion or a panic or a disputed sequence of events. So the reconstruction and forensic angle may also be raised by the police, but a good defense lawyer will treat it very carefully. How? Scene recreation can help investigators understand the possibilities. Again, scene recreation can help the investigators understand the possibilities, but it cannot mechanically recreate the human conduct. People do not fall in identical ways every time, guys. A dummy is not a human being with a balance or a panic or a movement or a resistance or instinct. So if police says that a reconstruction shows that the body must have fallen in a particular direction, the defense can counter it very easily. That the test only shows one possibility, my lords, not the only possibility. Terrain, slope, body position, momentum, footing, weather, and impact can all change the result. Am I clear, guys? Am I making sense, guys? These are things that needs to be understood. I am doing it just to make you guys understand how the system works. It is just basic things that we need to understand. I am also learning. I am making you guys share with my learnings, and that is why I need your attention at fullest, because these are the things that we learn over a period of time. But these are things, if you learn with process, you get and see things in the same way. It becomes very easy. It becomes very natural. So a reconstruction may support a version of what events. It may support कि हाँ ऐसे हुआ था वैसे हुआ था या ये हो गया, but it does not become the conclusive proof unless other evidences independently confirms that the same event or same story has happened. Now, let us talk about the actus reus and the mens rea, my favorite. And that is where the legal seriousness of this case becomes very visible. So, guys, in a murder case, it is not enough to show that a person died. What I said, in a murder case, it is not enough to show that a person died. What? Yes, death alone is not murder. The prosecution must prove the criminal act that the accused caused the death, and the mental element of that person supported and made that murder happen. So what if the Ketan fell accidentally? The actor's rears of the murder fails. If he was pushed, but there was no intention to kill and no knowledge of the fatal consequences in the legal sense, the charge may take a different shape altogether. It would be negligence. So, if there was a conspiracy, the prosecution must prove the agreement, the planning, and what the foremost important participation. If there was only relationship and suspicion, the prosecution still has to cross the legal threshold. That is why a lot of people, when I ask this question, what is the legal threshold of the crime that you're proving, they don't have the clue, because we do not understand the simple understanding of the same. We read cases, we read 10,000 cases, but if we cannot develop the acumen, we will always fall short. So that is why, and this is why a defense lawyer will keep hammering the same theme, that the court cannot convict just because the story is ugly, guys. The law punishes proven conduct and not what on social media reaction or emotional reaction altogether. Now, the no reasonable alternative standard, which is perhaps the most important concept here, which you guys have to take a grasp of it. The prosecution must not merely show that it is theories. Its theory is plausible. It must show that no reasonable innocent explanation survives, my lords. There is no reasonable innocent explanation we have. If the defense can say that the Ketan may have slipped, or that the fall may have been accidental, or the terrain was dangerous enough to allow a fatal accident, or that the digital trace does not specifically push or prove a push, then the reasonable doubt may arise. The burden is not on CR to prove that she is innocent. The burden is on the prosecution to prove that she is guilty. That burden never shifts in a murder case. Remember always, burden never shifts in a murder case. This is the deepest mistake the public makes. People often think that the accused must explain the everything. Legally, that is not true in the same way, because the prosecution has to make out the case first. Now, if we merge all this with the facts, the prosecution's strongest narrative would be something like this: that Sia was engaged to Ketan, but allegedly did not wanted to marry him, was secretly involved with this this boyfriend, and feared the social consequences of the cancelling the engagement. Therefore, the police alleged the two planned they to plan to eliminate the Ketan by taking him to the Lohagarh fort, where the terrain and gorge could make the death look like an accident. They allegedly communicated extensively. Possibly, they have searched for methods of killing. They met secretly and used a combination of planning and opportunity to make the scene look natural. The prosecution would then say that Sia's called to Ketan's mother, the alleged presence of Chetan, the CCTV, the digital traces, and the alleged lack of remotes all fit in the same pattern, my lords. And that is the story prosecution will try to tell and will connect with all of the circumstances, facts, digital traces, everything. But the defense will attack the story piece by piece. I would I would do if I would have been the defense lawyer, I would do the same. First, I would say that it will say that the relationship evidence proves contact, not murder, my lord. Second, I will say that the engagement and family pressure create the motive for emotional conflict, my lords, and not necessarily for a homicide altogether. A homicide has to be with the mental element. What is the mental element, my lords? The motive is clear. Where is the mental element? that she had the knowledge and the intent to kill. Third, I will argue that the alleged search history and chats need proper electronic proof and may not show the criminal intent altogether. Further, it will say that the fort was dangerous, so a fall is not implausible. And fifth, it will challenge, and I will challenge the identification of the hooded figure. And sixth, I will argue that the behavior after the event is not enough to prove the killing, my lords. Seventh, I will pass that if there is no eyewitness, no direct footage, and no weapon, then the prosecution must rely entirely on circumstances that are each vulnerable to innocent explanation, my lords. And this is why the case is so legally interesting, you see. It sits at the intersection of a digital evidence, circumstantial evidence, motive, and the public outrage altogether. It is exactly, the kind of a case where the media wants a villain very quickly. Everybody around us want a villain. But law, as a legal acumen, it does not take the forecourts in such an easy manner. Law wants a chain of proof, slowly and carefully built. If the prosecution can connect the relationship, the planning, the presence, the opportunity, the conduct, and the forensic findings into one uninterrupted chain, a conviction is possible even without an eyewitness. But, but, if any major link is broken, if the electronic evidence is weak, if the identification is uncertain, if the forensic findings do not distinguish a push from a fall, or if another reasonable explanation survives, then the defense may succeed simply by showing a doubt. So, when a lawyer argues from the SCR sides, the argument is not necessarily that nothing happened. The argument is what happened has not yet been proven in the legal sense. It is that the court must not confuse suspicion with proof, motive with a murder, or a presence with participation. The lawyer will insist that every electronic record be properly proved, every allegation of planning be supported independently, every CCTV frame be tested for clarity, every forensic conclusion be challenged, even every gap in the prosecution story be treated as a reasonable doubt. And that is how criminal law works. It is not about who tells the most dramatic story. It is about who proves the complete one. And that is the real lesson of this case, guys. It is not merely a story of relationship gone wrong. It is a demonstration of of how criminal justice separates public belief from legal certainty, and that certainty should be rest apart. It shows why courts insist on admissible evidence, why the circumstantial cases must be built like a bridge with no missing support, and why the defense does not need to win the truth of the entire universe. It only needs to break one essential leg in the prosecution's whole chain. That is the law, that is the burden, and that is exactly will decide whether CR's case becomes a conviction or an acquittal or a long contested legal battle, where every fact must be weighed through care. Yes, guys, any questions? Yeah, I was about to tell this. In a death at a public site, the burden of proof does not automatically shift to the accused. In a criminal case, the prosecution still carries the primary burden to prove the accused guilty beyond the reasonable doubt, and that the ultimate burden stays with the prosecution throughout the trial. What can shift is the burden to explain the certain facts. Once the prosecution first proves a strong basic case, so in Indian evidence law, the initial burden lies on the party asserting the fact. Party U, the prosecution, and only after the prosecution establishes a prima facie chain can the accused be called upon to explain the specific circumstances within their special knowledge. So, in a public site death, if someone dies at a public site like fort, road, park, or station, the prosecution must first prove things like who was present, what was the terrain or scene was, whether there was opportunity, whether there is any CCTV phone data, witness account, or a forensic report, and whether the death looks accidental, suicidal, or a homicidal. So the prosecution can show the accused was last seen with the deceased and have surrounding facts strongly pointing towards a foul play. Then the accused may have to explain what happened. But that is not the reversal of the whole burden of proof. It is only a shift in the burden of explanation for facts, especially within the accused knowledge. So, for example, if a person dies after falling from a fort and the prosecution proves the accused was alone with the victim at the relevant time, then the court may expect that the accused to explain the circumstances of the fall. But the prosecution still must prove that the death was not a mere accident, and that the accused version is false beyond reasonable doubt, and it shapes no other innocence formula to leave this person innocent. So the rule is prosecution proves the case first, accused may then need to explain the circumstances, but the final burden never leaves the prosecution in a criminal trial. Am I clear, guys? Thank you. Yes, yes. So a complete circumstantial chain is one where the every important circumstances is independently proved. All the circumstances fit together. The only legal conclusion is guilt, and no reasonable innocent explanation survives. In Indian criminal law, courts often repeat that the chain must be complete in all respects, and if even one essential link is missing, the accused gets the benefit of doubt. Yeah, yeah, okay. So a strong circumstantial case often has several type of linked working together. Last seen together, showing the accused and deceased were together near the time of death. Motive, showing why the accused may have wanted the crime. Opportunity and presence, showing access to the victim and scene. Conduct after the incident, after the ghatna, such as lies that were told apparently by that was told by Ketan's sister that Sia was lying when she earlier had a discussion about the incident, and then later after the therapy when she had a discussion that was different. So these are the lies, flight, concealment of any false facts, or a destruction of evidence. Fourth, it would be forensic proof such as injuries, what kind of injuries, blood patterns, DNA, phone data, a CCTV, or a recovery of any object that is there on the dead body. So these are the things. No, so the chain is complete only when the proved circumstances point to one conclusion only, that is guilt. The circumstances must also be consistent with each other, should not be contradictory, and must rule that that it should rule out other reasonable possibilities like accident, suicide, or another offender. So these three things should be moved out or carved out to have the reasonable possibility. So as a prosecution, you should evacuate, and I would suggest that always think in a manner that you are evacuating or you are isolating this incident from accident or a suicide or any other offender who was present at that moment of time. So when you carve out these three things, you automatically leave no stone unturned to have the guilt. So while link matters, the courts do not convict on suspicion, and they do not allow a probable guilty theory to replace the proof. So if the prosecution proves that the accused was present and had a relationship or had a motive, that still not be enough unless those facts connected to the actual act that was happened at the Lohagarh fort and exclude the innocent explanation. So in a case like a fall from a shot of public places, the prosecution usually needs a chain to show, है ना? That should have conclusive evidence to prove that it has happened. That supports this incident was there and was the evident thing that can happen. So yeah, these are the things that needs to be understood. But I would suggest you a few cases to read. There's a case called Hanumant Govind Nangundkar. 1952 का case है. One of the earliest leading cases. It laid down the circumstances must be fully established and consistent only with the guilt of the accused. फिर then you can go with the Sharad Birdi Chand Sarda versus State of Maharashtra, I guess 1985-1986 का case है. It sets out the famous five golden principle for conviction and on circumstantial evidence, and states that the chain must exclude every possible or reasonable hypothesis except the guilt. सवाल दास का केस पढ़ सकते हैं आप 1974. It is often cited for the principle that circumstantial evidence can sustain conviction if the chain is complete. Yeah. So another case could be State of Maharashtra versus Suresh, which is it is generally relied on for the rule that motive, conduct, and the surrounding facts can together build a prosecutable chain when direct evidence is absent. So yeah, that is how circumstantial evidence became relevant. Lakshman Prasad versus State of Maharashtra could be a very recent case where Supreme Court reiterated that if one link in the chain is missing, conviction cannot stand. Uh, Abdul Nasser versus State is a very famous case which is cited in recent commentary as reaffirming the need for a complete chain that excludes other theories. So This is how it would work. Acha, hearsay and circumstantial evidence in law. So hearsay means and substance are very different things in law, because hearsay is a statement where the witness says that someone else said instead of what they personally saw or heard. For example, I know he did it because my friend told me so. That is usually weak and often inadmissible unless a legal exception applies, of course. Circumstantial evidence is not a second-hand story. It is a proved fact that from the court, that which the court may infer another fact. For example, seeing the accused near the scene, phone location data, or conduct after the ghatna can all be circumstantial evidence if properly proved. So that is the core understanding of the same. Other than that, role of cross examination in challenging, yeah, it is very very important. See, so cross examination is one of the main tools a defense lawyer use to break a circumstantial case. It is where the lawyer tests whether each fact the prosecution relies one on is actually reliable, consistent, and has a strong enough to support the next link of the chain or not. So that is very very important, guys. Matlab, that is the hands down, that is you have to understand it with full sense if you are proceeding with this. Yeah. Okay. Yeah, okay. Okay. हम्म, हाँ, तो वो चीज़ रहेगा, आप समझिए ना इस बात को कि होता क्या है। आई एम स्विचिंग फ्रॉम इंग्लिश टू हिंदी। ओके। तो हम्म, नहीं देखिए, अभी सारी चीज़ें जो हो गई हैं, इन चीज़ों को आधार पर क्या आरसी और केतन को सजा दिलाई जा सकती है। क्योंकि देखिए, सबसे इम्पोर्टेंट अब जो पुलिस के पास अभी तक क्या क्या है, ये आपको बताया गया होगा कि और इससे क्या क्या हो सकता है, ये आगे मैं बताऊंगा। लेकिन जो पुलिस के पास नहीं है वो क्या नहीं है। पहली बात तो जो मैंने बताया कि कोई चश्मदीद नहीं है, कोई आई विटनेस नहीं है, कोई किसी ने देखा नहीं कि सिया ने सीधा या किसी और ने धक्का दिया हो, उन्होंने धक्का देते हुए नहीं देखा। आज इस केस को खुले हुए पूरे समय हो गए, 23 जून से यू नो ये सिचुएशन पूरी हम लोग के सामने है। अभी तक पूरे पुलिस की अपील के बावजूद एक भी विटनेस सामने नहीं आया है जो ये क्लेम कर सके कि उसने 18 जून की सुबह केतन को धक्का देते हुए सीधा सिया को देखा था। और उम्मीद भी नहीं है कि कोई विटनेस आएगा कि अ, उन्होंने किया या सच हुआ या पता नहीं कैसे हुआ, या किसी कैमरे में कैद किया हुआ ये इंसिडेंट बिल्कुल नहीं है, कुछ भी नहीं है हमारे पास। सीसीटीवी कैमरे में सिर्फ फुटेज में तस्वीर है चेतन की। अ, धक्का मारते हुए कोई वहां पर था नहीं, कैमरे में भी नहीं था। बेवकूफ वो थे नहीं कि कैमरे के सामने धक्का मारते, मुझे लगता है ऐसा। तो मतलब ना विटनेस है और ना धक्का मारते हुए किसी को सीधे सीधे एविडेंस के तौर पे पेश किया जा सकता है। अब क्या किसी केस में अगर कोई चश्मदीद ना हो, कोई कैमरे में कैद ना हुआ हो, तो उसे सजा दिलाई जा सकती है? बिल्कुल दिलाई जा सकती है। बहुत सारे ऐसे केस हुए हैं, लेकिन उसके लिए आपको पूरी कहानी ढूंढनी पड़ेगी, जो मैं बात कर रहा था। और एक कहानी हवा हवाई नहीं है बिल्कुल, बल्कि बल्कि उन कहानी की हर कड़ियों को आपको तोड़ना होगा। कहानी का एक भी अगर कहानी का एक भी कड़ी अगर वो उस चीज को तोड़ रहा होगा, एक भी कहानी को तोड़ रही होगी किस तरीके से, तो केस बिखर जाता है। अब कैसे सिलसिलेवार तरीके से अगर इसको समझना हो, इस केस में विटनेस नहीं है, कोई सबूत नहीं है कि केतन को धक्का देकर नीचे फेंका गया या केतन ने सर पर गिर गया। रिक्रिएशन हुआ भी था अभी, अब उससे क्या हुआ जो मैंने बताया अभी था, कि रिक्रिएशन से क्या ही हो जाएगा। तो बहुत सारी ऐसी चीजें हैं जो एज अ डिफेंस लॉयर आप यूज कर सकते हैं। आप 10 बार गिराइए किसी को उस जगह से, हर बार अलग अलग होगा, एक ही जगह नहीं ना गिरेगा कोई आदमी। दूसरा, एक आदमी खड़ा होगा, अगर किसी हादसे में होता है, फिसल के नीचे गिरा, आप ऐसे 5 अलग अलग आदमी के ऊपर से फिसलते हुए नीचे गिराइए, 5 अलग अलग तरीके से गिरेंगे, तो फिर डमी ट्रायल और फिर रिक्रिएशन का क्या फायदा? कोई फायदा है? मुझे तो नहीं लगता, क्योंकि ये फैक्ट है कि हर आदमी अलग अलग अंदाज में गिरता है, और डमी तो वैसे भी अलग अंदाज में गिरेगी। तो डमी ट्रायल और रिक्रिएशन से कुछ होना नहीं है, पहली चीज। दूसरी, इससे पूरे मामले में पुलिस को केतन का अगर कत्ल हुआ है तो कत्ल का मोटिव यानी मकसद क्या है, ये साबित करना पड़ेगा। और हर कत्ल में यही कहता है कि आपके सामने मोटिव क्लियर होना चाहिए, मकसद। अब यहाँ मकसद पहले ही दिन से क्लियर कर दिया गया कि जो जो क्या था, कि मकसद ये कि सिया और केतन की सगाई हो गई। सिया शादी करना नहीं चाहती थी, केतन से उससे प्यार था, जो भी उसका दूसरा बॉयफ्रेंड था वो केतन से शादी करना, वो उस बॉयफ्रेंड से शादी करना चाहती थी, घर वालों को भी वो कहकर शादी करने की हिम्मत नहीं कर पा रही थी, इसलिए केतन के साथ साजिश, जो एलिजेड बॉयफ्रेंड है उसके साथ साजिश रचकर उसने शादी से पहले ही केतन को हटा दिया रास्ते से। ये मोटिव है। जो अब तक की पुलिस की लाइन की कहानी है वो यही है। इसके अलावा कोई दूसरा मकसद नहीं है कि पैसों के लिए मारा, रिश्तों के लिए मारा, झगड़ा हुआ तो इसलिए मारा, वो जिम्मेदार नहीं है, वो जिम्मेवार नहीं है। क्योंकि अभी तक आपने जितना पढ़ा लिखा सुना देखा है वो यही है जो पुलिस लाइन की लाइन है। ये कत्ल केतन का इसलिए हुआ कि सिया जो है शादी नहीं करना चाहती थी, केतन से करना था उसे, जो भी एलिजेड बॉयफ्रेंड उससे करना था, और इसलिए केतन को निपटा दिया गया। अब इस मोटिव को साबित कैसे करेंगे आप? तो फिर मैं आपको उन चीज़ों पर घूमते फिराते ले आऊंगा। मैंने आपसे कहा कि डमी ट्रायल और रिएक्शन रिक्रिएशन इस मोटिव को साबित नहीं कर सकता है। अदालत में कोई भी चैलेंज कर सकता है अगर अगर केतन वहां गिरा हो, डमी गिरी, ये दो गिरी, फलानी चीजें गिरी, इसमें कोई मतलब नहीं है। कोई फिसल को कैसे धक्का खाकर गिरेगा, ये अलग अलग सिचुएशन में अलग तरीके से होगा। क्या एविडेंस है? नहीं है। तो ऐसी बहुत सारी चीजें हैं जो कि अभी भी अनडिस्प्यूटेड है, डिस्प्यूटेड रहेंगी। आप देखिए ना, मैं उम, दोनों बयानों में आप डिफरेंस देखिए। चेतन की स्कूटी, ये सारे सबूत जो है, इसके अलावा जो लोग का बयान है, जो केतन के परिवार के, आलेसिया के परिवार के, बॉयफ्रेंड के परिवार के, उसने सबने एस्टैब्लिश करना ये सिया और केतन का एक रिश्ता था, दोनों का रिलेशनशिप में थे, अफेयर था, या दोनों का कुछ और था। तो ये सारी चीजें मोटिव को फेवर की जाएंगी कि हाँ इन दोनों के बीच ने ही ये खेल लिया है और निपटा दिया है। लेकिन कोर्ट में ये सिर्फ एक प्रस्तुति पर खड़ा नहीं होना है। इस पूरी प्रस्तुति पे सिया को सजा नहीं मिल सकती है, ना ना उस एलिजेड बॉयफ्रेंड को। अब इसको अगेंस्ट में ले जाता हूँ, मोटिव नहीं है क्योंकि अभी तक कोई मोटिव तो कोई और सामने आया नहीं, तो उसी मोटिव को लेकर चले गए कि सिया और केतन एक दूसरे से प्यार करते थे, सिया केतन से शादी नहीं करना चाहती थी, रास्ते से हटाना चाहती थी, इसलिए लेकर उसे मार दिया अपने बॉयफ्रेंड को लेके। अब वापस सबूत क्या है? पहला क्राइम सीन पर सिया क्यों मौजूद थी? अब मैं उल्टा जा रहा हूँ। क्राइम सीन पर सिया की मौजूदगी उस दिन केतन के साथ थी या और कोई भी था मौजूद, जो सॉरी एलिजेड बॉयफ्रेंड के साथ था या और किसी के साथ था, तो सिया ही कातिल आउट हो सकती थी। लेकिन ये कैसे साबित होगा? क्राइम सीन पर सिया की मौजूदगी की और भी वजह हो सकती है। वो दोनों मंगेतर थे और उस दिन उनके साथ में इससे पहले भी साथ आए थे, और सबूत तो अभी भी खड़ा किया जा रहा है ना कि सिया की मम्मी ने एक स्टेटमेंट दिया 18 तारीख को, सिया असल में जाना नहीं चाहती थी, केतन ने फोर्स किया था उसको। और इस बात को कि उन्होंने दावा भी किया कि उसके मोबाइल में टेक्स्ट मैसेज भी है कि सिया कह रही है कि हम नहीं जाएंगे, थके हुए हैं, अगले दिन बर्थडे पार्टी में जाना है। लेकिन केतन ने फोर्स किया कि भाई चलते हैं। तो क्राइम सीन पर सिया की मौजूदगी ही ये साबित नहीं कर सकती कि सिया ने मारा है, क्योंकि अगर ये बात मोबाइल की कॉल डिटेल से या वीडियो कॉल से या और मैसेज से ये साबित हो गया है कि सिया जाना नहीं चाहती थी, तो उस दिन का मोटिव खत्म है कि नहीं? उस दिन का केतन उसको जबरदस्ती ले गया था, फोर्स करके। तो एक जिस तरह से उसकी माँ खड़ी हो जाती है, तो ये केतन को उस पहाड़ी पर ले जाकर धक्का देने वाली साजिश रची थी सिया ने। क्योंकि साजिश रचने का मतलब ये है कि सिया उसको ले जाएगी, चेतन जबरदस्ती नहीं ले जा सकता। अगर केतन के कहने पर फोर्सफुली गई तो फिर ये साजिश कहाँ से हुई? है कि नहीं? साजिश का एंगल रूल आउट हो गया यहाँ से। तो क्राइम सीन पर मौजूदगी ही सिया को गुनहगार नहीं ठहरा देगी, जो मैं बता रहा हूँ आपको। केतन की मौजूदगी, और फिर केतन भी उसी किले पर निकला था और दोनों प्रेमी थे। दिस केतन मैं बार बार कह दे रहा हूँ, उसका एलिजेड बॉयफ्रेंड निकले थे। दोनों प्रेमी, और ये दोनों एक साजिश करते समय, मतलब साजिश की एक मनगढ़ंत, मतलब साजिश की कहानी बताई जा रही है, और उन्होंने धक्का दिया, और वो सीसीटीवी कैमरे में उसकी तस्वीर भी आप देख सकते हो। लेकिन यहाँ भी वकील तर्क देगा और आ सकता है कैसे कि चेतन और जो एलिजेड बॉयफ्रेंड और सिया दोस्त थे, ये बात सिया के भाई साहिल को भी पता थी। और जब ये जाने वाले थे उससे पहले, जिस तरह मैंने कहा कि सिया की माँ का ये दावा है कि 18 तारीख को केतन ने फोर्स किया था कि किले पर जाने के लिए, सिया ने नहीं। उसी तारीख से केतन के फादर ने एक और बात कही थी, अगर आपने वो देखा हो। उन्होंने कहा था कि सिया 18 जून को ये कहकर केतन को ले गई कि उसका बर्थडे है, बर्थडे से पहले एक दिन पार्टी करनी है, पहले पार्टी करनी है, उससे कुछ दोस्त होंगे वहां पर पार्टी करने के लिए। और अगर आपको ये थोड़ा सा याद नहीं है तो सिया की माँ का और के दिस केतन के पिता, जो दोनों ने 2 बार नहीं गई, ये मैं इसके सुनना चाहता हूँ क्योंकि अ, इसमें बहुत इंपॉर्टेंट एविडेंस है। मम्मी जी मैं ट्रैकिंग के लिए जा रही हूँ, तो मैंने बोला कि बेटा, ये उसकी मम्मी कह रही थी कि ट्रैकिंग के लिए क्यों जा रही हो। उन्होंने मेरी रात की उसकी मम्मी से बात की, उन्होंने कहा कि बात की बात हुई है। मैंने उसकी मम्मी को जी को भी बताया कि मम्मी चेतन बोल रहे हैं कि चलने के लिए, पर मैंने उनको मना किया है, मैंने इशारे किया था कि मम्मी आपको उनको मना करना है। उन्होंने बोला कि नहीं, जो बोल रहा है ना वो केतन करो। ये उनकी किसकी, सिया की माँ बोलती हैं। अब सिया ने बोला था मम्मी जी उस आप से पूछो कि बोलो कि हम लोग ट्रैकिंग नहीं जाना है, तो उन्होंने बोला कि ठीक है बेटा, उसकी ही इच्छा है तो चले जाओ, ये सब उनकी मम्मी ने कहा। फिर इमीडिएटली उसने फिर बोला 18 तारीख को मेरे को फिर जाना है लोहागढ़, जबकि 19 तारीख को उसका बर्थडे था, महाबलेश्वर में सेलिब्रेट करने वाले थे, ये उसके पिताजी बोल रहे थे। लेकिन उसने क्या बोला, नहीं मेरे दोस्त कुछ पार्टी रखना चाहते हैं, तो कुछ लड़के लड़कियां हैं। केतन को उसने ऐसा कन्विंस किया कि कुछ भी कर पाना अपने बर्थडे पे कुछ और कर पाना संभव नहीं था। उसने फिर अपनी उसकी मम्मी को, उसके केतन के मम्मी को भी रात में फोन नहीं किया, चलो बर्थडे है तो जाके चले आएंगे, है ना। तो आपने दोनों तरफ की कहानी समझ ली, आपको 2 अलग अलग स्टेटमेंट दिख रहे हैं, 2 अलग तरह की बातें हो रही हैं, है ना। तीसरा क्या है कि ये पूरी कहानी जो है, कॉल डिटेल, मैसेजेस, ये सारी चीज़ों को ले लेते हैं, जिनसे जिनसे इन दोनों का रिश्ता स्टैब्लिश होता है। ये दोनों मान लेंगे कि हाँ हमारा अफेयर है, हमारा प्यार था, हम मिलते थे, हम बात करते थे, हम घंटों बातें करते थे, हमने हजारों कॉल किए एक दूसरे को, लेकिन हमारे रिश्ते का इस मर्डर से क्या ताल्लुक था, क्या लेना देना था। हमने तो कोई दूसरी बार में सोचा तक नहीं था। और अगर इसका कोई सबूत है तो आप ले आइए। अब रिश्ता तो स्टैब्लिश हो रहा है, लेकिन इन दोनों का केस, जो एलिजेड बॉयफ्रेंड है और सिया का रिश्ते से केतन के मर्डर का क्या रिश्ता जाकर जुड़ता है, इसका प्रूफ या सबूत कहाँ है? यही पूरे पुलिस को ढूंढना है ना। तो आपको दोनों तरफ के जो वकील हैं, जितने लोगों से बात की, ये होगा वो होगा, मैंने आपको बेसिक अभी ये मतलब मैं समझा सकता हूँ। बाकी देखिए कैसे ये केस डेवलप करता है, देखते रहिए, समझते रहिए, तो आपको समझ में आता रहेगा कि ये किस तरह से